Bless you. Court calls the case, People versus Samira Smith.
Senior Assistant Public Defender representing Ms. Smith. Ms. Smith, would you please state your name?
Samira Smith.
Thank you.
Your Honor, at this time, Ms. Smith will be waiving the preliminary examination. She is aware that there are no offers, but we are continuing to discuss matters with the prosecutor and are also hoping to be able to work out a COTS agreement. Is that correct, Mila?
All right, you understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offense was committed and that you committed it. You understand that, ma'am? And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single. Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client wishes to stand mute and have the court enter a not guilty plea.
Defendant having waived reading standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
August 12th at 1:30 before Judge Slay Monday.
August 12th, 2024, 1:30, Slay Monday.
Your Honor, may we address bond, please?
Right.
Your Honor, my client is a young woman. She's 20, just barely, just soon to be 21 in a few weeks. She has had a very challenging past few months. She has been, she recently had a son who is about a year old now. Her mother died unexpectedly in April of this year. And she has just had a very hard time financially, emotionally, and it's manifested in many different ways, which includes having had some prior trouble in Oakland County before this, for which she is on probation. And we do believe that there are holds for Oakland County. We are asking, however, that the court consider giving her a bond that she could post. We're asking if the court will not consider a personal recognizance bond, a $1,000 cash or surety bond, so that she can get to Oakland County and begin to resolve those matters as well. My client, as I said, has a 1-year-old son. At this time, her 85-year-old grandmother and her older sister are looking after him, but she does have Section 8, which is of great value to her and her son. And she would like to be able to keep Section 8, and an extensive amount of incarceration will impact her ability to do that.
Ms. Gaines, is she on probation on 9 offenses out of Oakland County?
Okay.
I think it's 2 cases and between them, the 9 counts.
So
So yes, I'm saying correct. I just don't know the number of counts. I knew the number of cases.
okay.
She does have family support. Her cousin, David John, is here in the courtroom. He indicated that her grandmother is trying to get here. And she would return to her address in Detroit, where she does have the voucher and would be able to take care of her son upon completion of the Oakland County matters, she hopes.
Did she violate on the Oakland County matters?
I do believe that there is a violation of probation, holds out of Oakland County as a result of this matter.
I don't necessarily need anything from the people unless you want to say something. Motion for bond reduction is denied. Bond will continue.
Thank you.
A plea agreement, and that form should have been tendered to Your Honor and to defense counsel.
I do have it. The form indicates that the defendant will be pleading guilty to child abuse 4th degree, punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count one would be dismissed. There is no other agreement.
That is correct, Your Honor. Carlson, could
Sean Matthew Carlson.
Has he signed an advice of rights form, counsel?
not to my knowledge, Your Honor. I can have him sign one right now.
Have the defendant sworn, please.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that? Mr.
I
Reisner?
don't believe so. 1 year or probation or up to 5.
5 years, no maximum.
1 year
All
or
right.
jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. And you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
Yes, Your Honor.
And that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached Anthony, the minor child, and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
Yes, Your Honor. I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No.
Your Honor, would the court accept a no contest plea?
I don't know if the deal was continued upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Do this. Why don't I pass the matter? Counsel, why don't you talk to your client
Yes, Your Honor.
and then I'll call you guys back up and let's see what we can do.
Thank you, Your Honor.
Thank you.
Senior advisor again on behalf of the people, yeah.
Assistant Public Defender Davey Lieb on behalf of Mr. Carlson, who stands to my right. Mr. Carlson, can you state your name, sir?
Sean Matthew Carlson.
Thank you for the court's patience, Your Honor. I have had additional discussions with Mr. Carlson as well as the conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
Do I have? Oh,
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1, Ann Arbor Police Department Report 24-7-818, and marked the injury to the child and the relationship and the statement from the report. And ask that be admitted on the basis of.
Any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
That being 24-7-818 of the Ann Arbor Police Department. Sir, the understanding is you wish to plead no contest?
Yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
All right. You understand that all the rights that I explained to you apply to a no contest plea?
Yes, Your Honor.
And everything is exactly the same. It's just that you are pleading no contest to the charge. You understand that?
Yes, Your Honor.
So to that charge, how do you plead?
No contest.
Review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense. Counsel, have I complied with the court?
Yes, the people are saying.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
August 30th at 9:30 before Judge Terry.
August 30th, 2004, 9:30 before Judge Perry.
Your Honor, you could just check on the form that it was a no contest plea, and the one other additional part that I believe was discussed between parties is there will not be a delayed or a deferred.
Is that correct?
That was discussed, Your Honor.
Well, was it agreed to?
In terms of my discussion with Ms. Willenbring, I believe I just asked if she would be offering one. I don't know that we necessarily agreed that we would not be seeking one. However, that may have been a discussion with the previous attorney.
What?
That may have been a discussion with the previous attorney on the case.
And so it's like just maybe a miscommunication. No, we're not offering one means that the reduction happens and we're not offering it and he's not seeking it.
And that is correct.
So that is correct.
Yes, Your Honor.
He's not going to be seeking delayed or deferred.
That is correct.
You understand that, sir?
Yes, sir.
Thank you.
He's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
And so what's the status currently?
The child is residing with Mr. Carlson. Under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintain some involvement.
Okay, so what is that involvement?
Just recently, my CPS social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes. And Protective Services thought it was still okay for him to be with me.
And I got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face and coming before a court and telling me that. So you're lucky to be leaving today.
Fair enough.
You may leave.
Thank you.
Thank you.